friends, today we will be talking about custodial crimes or custodial violence. In this age of democracy and liberal thinking, especially in a democratic country like India, concepts like custodial crimes, torture and the practice thereof are neither acceptable nor appreciable. However undesirable it may be, custodial crimes and torture in police custody still continues in India. Custodial crime is the worst form of crime as it is done by those who are supposed to be protector and guarantor of our rights, both human and legal. It is always done under the guise of power, backed by authority and uniform. It becomes difficult for the victims of custodial crimes to overcome the trauma they have undergone within the four walls of lockups or police custody. In the name of finding out the truth or collecting evidence, police uses custodial crimes and torture. No penal provision or any other legal provision gives any precise definition of torture and custodial crimes. However, in general, by custodial crimes we mean violence inflicted upon an individual in police custody. The World Medical Association in its Tokyo Declaration 1975 defined torture as the deliberate, systematic or wanton infliction of physical or mental suffering by one or more persons, acting alone or on the orders of any authority to force another person to yield information, to make a confession or to make any other reason. Article 1 of the United Nations Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment defines torture as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person, or for any reason based on discrimination of any kind. When such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity, it does not include pain or suffering arising only from inherent or incidental to lawful sanctions. The definition of torture provided in Article 1 of the United Nations Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment is much wider in scope and exhaustive than the other definitions mentioned above. Now let us make the analysis of the definition of the custodial crimes or custodial violence. If the definitions mentioned above are considered, then to constitute an offence of custodial crimes, the following ingredients are essential. It should be any form of torture. Torture may be done physically or mentally. It should be premeditated, deliberate, systematic, willful and without any logical justification and legal sanction. Such pain or suffering inflicted by or at the instigation of or with the consent or acquiescence of a public official or other persons acting in an official capacity, for the purpose of obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person in whom he is interested, or for any reason based on discrimination of any kind. Now let's talk about the various laws against the custodial violence in India. First we'll talk about the provisions under Indian Constitution. The very spirit of condemning custodial violence is mentioned in Article 21 of the Constitution of India, where it has been specifically stated that no one can be deprived of his right to life and personal liberty except by a procedure established by law. However, besides this, Articles 20 and 22 of the Constitution also play an important role in banning custodial violence. On the one hand, where Article 20 via its various clauses provides protection against ex post facto laws, double jeopardy and self-incrimination. Article 22 on the other hand mandates the conveying of information relating to one's ground of arrest, one's right to be defended by a legal practitioner of his choice, protection against preventive detention laws, and production before the nearest magistrate within 24 hours from the time of arrest. Now have a look of the various provisions under the Criminal Procedure Code 1973. Section 46 Clause 3 specifically states that nothing in this section gives a right to cause the death of a person who is not accused of an offence punishable with death or imprisonment for life. In furtherance to the said section, Section 49 protects the right of the arrested person by stating that the person arrested shall not be subjected to more restraint than is necessary to prevent his escape. Section 50, Section 50A, 56 and 57 protect the rights of the arrested person in consonance of Article 22 of the Constitution. However, Section 54 of 1973 Code specifically preserves the right of the arrested person against custodial violence and torture by laying down the provisions of compulsory medical examination of the arrested person. Besides this, Section 55A casts a duty upon the person in whose custody he is kept to take reasonable care of his health and safety. Section 176 is a very vital provision added in 1973 Code to curb the recurring incidents of death and rapes in police custody by assigning power to the magistrate to hold an inquiry of such offence and to take necessary actions. Whenever a death takes place in police custody, the procedure under Section 176 of the Code of Criminal Procedure is required to be followed. Under subsection 1 of Section 176 of the Code, when a person dies while in police custody, a magistrate may hold an inquiry into the cause of death, which will be either instead of or in addition to the investigation held by the police officer. Now let me tell you the various provisions under Indian Penal Code 1860. After the landmark judgment in Mathura gang rape case, popularly so known, Section 376 of IPC was amended and rape in police custody was made a punishable offence. Further, Section 166, Section 330, Section 331 and Section 348 protect the rights of the arrested person against torture by imposing duty upon a police officer, violation of which would amount to a punishable offence. Now here are some provisions under Indian Evidence Act 1872. Section 24, Section 25, Section 26 and Section 27 preserve the right of an arrested person by adducing no evidential value to the confession or admission made by him during his subsistence in police custody, and the same can only be used for corroboration and contradicting during the trial. Now I'll be telling you the various provisions under Indian Police Act 1861. Section 7 and Section 29 of the Police Act 1861 provides for suspension, dismissal and penalty of negligent police officers in discharge of their respective duties. Now some international instruments regarding the prohibition of custodial violence. The issue of custodial violence and torture has been a matter of great concern. Through various conventions and resolutions, such violence has been condemned. In order to recognize the inherent dignity and inalienable rights of all members of human family and reaffirm faith in fundamental human rights, dignity and worth of human person and equal rights of men and women, and to promote social progress and better standards of life, the Universal Declaration of Human Rights was made on 10th December 1948. Article 5 specifically states that no one shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment. The International Covenant on Civil and Political Rights came in force on 23rd March 1976, where in Section 7 it clearly states that no one shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment. Another resolution was adopted by the United Nations for the protection of the rights of the victims of torture and abuse of power. This is known as Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, 1985. In spite of the international agreement, the incidents of custodial violence and torture continues in India. Now let's have a look of the judicial response to custodial violence in India. Though there are various provisions of law dealt under various acts which ban the infliction of custodial torture, yet they fail to provide an effective check. Due to this failure, numerous incidents of custodial torture resulting in many cases to deaths have been reported. In one such case, Kishore Singh versus State of Rajasthan, the Apex Court again clarified the legal position by holding the third degree method used by police to be violative of Article 21 of the Constitution of India, and also directed the government to take appropriate steps to educate the police so as to inculcate respect for the human rights. Having regard to the reluctant attitude of the executive to formulate strict rules of conduct of the police towards the arrestee, the Honorable Supreme Court considered the matter in D.K. Basu versus State of West Bengal. In the said case, the Supreme Court considered custodial death as the worst form of a crime in a civilized society and laid down detailed guidelines to be followed in every case of arrest and detention, till any legislative effort is made in this context. But till date, no statutory law has been made in this respect. Before the landmark judgment Neelabati Behra versus State of Orissa, the law was silent on the point of paying compensation to the victims of custodial violence. With this, two other questions were also related. First, who would be treated as a victim, and second, even if the victim is entitled to compensation, who will be liable to pay the same? To fill up this legal vacuum, the Honorable Supreme Court in Neelabati Behra versus State of Orissa held the state vicariously liable for the act of its delinquent officers and awarded a compensation of Rs 1,50,000 to the mother of the deceased who died due to beating in the police lockup. With this decision, there emerged a new compensatory jurisdiction, and this trend was reflected in many subsequent decisions of the Supreme Court and various high courts of the country. Now we will discuss about the remedies against custodial violence. Monetary compensation. A claim for compensation is enshrined in Article 21 of the Constitution for contravention of human rights and fundamental freedoms. It is an acknowledged remedy for the enforcement and protection of such rights. A claim for monetary compensation for the violation of human rights in custody is based on no fault liability principle. Civil remedy. The award of compensation in the public law jurisdiction is also without prejudice to any other action like civil suit for damages which is lawfully available to the victims or the heirs of the deceased victim with respect to the same matter for the tortious liability committed by the functionaries of the state. Criminal liability. Under section 330 of IPC, whoever voluntarily causes hurt for the purpose of extorting from the sufferer or from any person interested in the sufferer any confession or any information which may lead to the detection of an offence or misconduct shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. So, to conclude, we can say that custodial violence in any form, if goes unpunished, has a potential to shake the foundation of the criminal justice. Prisoners, even though they are deprived of liberty, are still entitled to the basic human rights. In spite of various legal provisions and judicial decisions of the courts in India, custodial violence in India goes unabated. One reason for this may be lack of statutory law on this issue.